Then we again would be continuing to do the same thing against which we are talking about. Colin is asking me to start talking to you in Marathi. Is it okay?
No, sir.
Is it?
No, sir.
I can brush up on my Marathi.
You could mix.
Yeah.
What is the language?
Now there is a trend, yeah. Now there is a trend of talking in all languages. So whatever situation demands, we'll start talking in that language. Basically, I'm here to talk to you not about what's not possible in the court, but I would like to talk to you what can be made possible to work out in the court. How best we can use our skills for giving justice to the court. And I think apart from the court, there is no other forum which will help us in seeking justice for the poor at this pace. We go to any administrative agency, we go to any bureaucrat, I don't think he will be able to give you that justice which is available in courts. That facility that is available, that speed that is available in the court. If the court is convinced by what you are saying, the manner in which it can help you, nobody can. And I have experienced that. Not because I want to talk in favor of the courts that are existing today. But I would like to create an encouragement to you that even in the present system, we can use our skills and give justice to people. There was one case which had come to me, saying that one tribal boy was killed by the police, saying that he was an alleged Naxalite and an alleged encounter. And it was the case of the police that they had gone to search Naxals in the remote area of Gadchiroli, where suddenly a group of boys started firing at him. And they had to fire back. And in that encounter, one Chinna Mattami was killed. And he was labeled as a Naxalite. With that case, a case of an anti-Naxal movement, and Chinna Mattami being a Naxal who was trying to overpower the police was registered, and ultimately he was killed. One of his colleague was injured. So criminal case was registered. There was a lot of disturbance on this case because nobody believed that a boy like Chinna Mattami, who was not even holding a weapon, can be termed to be an Naxalite. And there was no possibility of he firing back on the police because he was at that time fishing in a very traditional manner, which doesn't give him any scope of using a weapon. He was using a pointed stick for killing the fish, and that's what he had in his hand. But the police could manage to create a scene that it was a case of encounter and a weapon was seized, etc. A magisterial inquiry was ordered initially. And I was shocked to see the report of that magisterial inquiry. With all that pressure, that magistrate opined that this was not a proper encounter, this was not a correct encounter, this was a fake encounter. And this boy was killed accidentally, he said. Because the police were trying to overpower the Naxals. There was firing, and they backfired, and in which this boy was killed, but they didn't want to admit that. And they wanted to create a false story that he was the person who was also firing and he was killed. Even after this magistrate inquiry, the government didn't think it fit to take cognizance of the issue and accept that the police had gone wrong in this case and award a compensation to the victim and his mother. Some group of young workers in Gadchiroli took this issue, and I was so happy that I was a part of that process of taking the issue to the High Court in a writ petition. Long debates, prolonged arguments were conducted in that case. But after prolonged arguments, the judge, I must appreciate that the judges of the High Court really took a very serious cognizance of this issue. It was for a tribal boy to be, coming into limelight, and Chinnamattami was those days the most popular figure who was known, because all the time it was reflected in papers that this case is being heard today. The progress of that case was reported every day. And the judge, the division bench of this High Court, opined. It conducted a detailed inquiry like the executive magistrate. Again, it brought the charge sheet before it. It saw each and every statement that was recorded. It saw each and every circumstance that was reflected in the charge sheet, and after scrutinizing the charge sheet for 8 days, and after hearing the case for 8 days, they came to an opinion that no, this was a case of rape. And this boy was awarded compensation. The point that I want to convey to you is, if young people, the social workers and the lawyers, if they cooperate with each other, I think they can do wonders. If this case was individually brought, or if this case has no backing, no public support, probably this case would have been lost in all these bunch of cases, and it would not have come for hearing for a long time. But this group of young lawyers, this group of young people who are working in Gadchiroli, and I found that if lawyers and the social workers come together like we are today here, it can give us a lot of support to each other to help the poor person. This is one case which I would like to discuss with you. The other cases of similar nature from Gadchiroli district. There was a dam which was proposed to be built, and in which lot of people were going to be displaced. Basically the tribals. The government had taken a decision to construct the dam for certain reason, which of course there are some political reasons for that. But the people there started agitating. That agitation wasn't enough to stop the government from going ahead with the project. They started shifting people from there, forcibly. They started a signature campaign of tribals, asking them to forcibly sign certain papers saying that they want to give up their land and leave the land and go from that place. And they are ready to settle somewhere else. Now this process generated a lot of social movement there. Again, this young group of people, they approached the court. And the court again took a very serious cognizance of this issue and gave a verdict that unless and until these persons are consulted whether they need this project or not, whether if a study is conducted which will prove that such a project is essential for this place, and whether the tribals want to be a part of that project, then only such project can go. The provisions of law were discussed. The displacement of people from the area where projects are undertaken, it was held that they should be first settled, and only after they are settled, And if they feel that such project is necessary, the project should go on. Now that compelled the government to rethink about the project, to rethink about the whole settlement program of these tribals if the project is found necessary. Now these are the two instances which I have been able to be associated with, which gave me a lot of confidence that it's not that the court will always be acting in a very limited sphere and not helping the court. I was told, and then also I was not very much encouraged to approach the court. But still, we made up our mind. We had a good teamwork. We had a good liaison with each other. We got a lot of data and lot of material from the people, grassroots level, and take it to the court, which couldn't be debated. The third incident was again of these tribals in Gadchiroli, which I had an occasion to handle. That the tribals, like the Chinnamatami, many of them were labeled as Naxalites. And it was alleged that they were helping the Naxalites to organize their movements, to have attacks on the government authorities. And tribals were compelled to attend the police stations, who were identified and who were to be identified, helping the Naxalites. Now these tribals were compelled by the police to walk 30 kilometers, 40 kilometers and attend the police station twice a week, thrice a week, to keep on giving their particulars as to where they were, what they are doing presently, who had been visiting them. Now this was absolutely illegal, which the police had no authority to do. They couldn't compel the police station to the tribals to visit the police station, and that to start labeling them, writing their names in a register, which, according to the police, were registers of the names of the tribals who were helping the Naxalites and acting in association with them. Now this was nothing but branding these tribals as Naxalites and aids of Naxalites. So a petition was carried to the High Court, and the High Court had in this case also immediately been able to stop this process. Otherwise this process was very difficult to be stopped otherwise. Lot of agitation was done at the local level. The tribals had met the police authorities, but it was of no help to them. Ultimately I found that in these three cases at least, the court had been able to immediately intervene and been able to take cognizance of this issue, which according to me it was impossible even if individually everybody of us would have started working on it. So I think the court can be used as an agency to immediately render justice to these people. But as it was said by Colin, it requires a lot of conviction. It requires a lot of encouragement. You see, I always feel that we are working for people who are suffering injustice. So we know for sure that our client are exploited. Our clients belong to a class of people who are an exploiters class of people. So we should feel more confident than the other side. Our confidence should always be more than a senior lawyer who is appearing against us. But in such cases I have found that people who are arguing these cases of people who are exploited feel defeated in argument. They are less powerful in argument. They get scared that they don't know much of the law when they know that the facts are on their side. The data available is on their side. The situation is depicted from papers which is on their side. I think when I started taking up these cases, I was hardly a lawyer who had put in about 5 years or 6 years of my practice. And I could, because I had a background, I came from a course which I did in the Tata Institute of Social Sciences, which helped me to associate or empathize with these people. So what I think that when we work on these cases of people who are suffering injustice, who are suffering exploitation, if we try to empathize with them as lawyers, it becomes very easy for us to agitate their grievances. Even if you are not aware of the latest position of law, if you don't have the best of the language to be used, if you don't know the best interpretation of a section, still you are in a position to convince the judges. Fortunately, there are certain judges who are taking cognizance of these cases immediately, and I must feel satisfied that the Nagpur High Court is one of such courts who have not only been dealing with these cases, but a lot of public interest litigations. I have been able to handle a number of public interest litigations. Rather, I started my practice by appearing in public interest litigation, and most of them have been very well taken by the courts. So I am not a person who would subscribe to the view that the courts are not a forum, presently at least, which cannot be used for getting justice to the people who are exploited. I think I have some other opinion to give. Not because I have been able to be lucky, but I feel that if a lawyer works by conviction, if a lawyer works with empathy to these people, it becomes very easy for us young lawyers to talk about exploitation of people. Even in cases which are not going to the High Court, but in other forums, like consumer forums, we can approach the court by way of associations, organizations. We have been able to do suits in a representative capacity even in civil courts, where we can take a group of people, where we can take a representative of people and approach the courts in civil court. That also we have been able to practice. We have been also able to work very well in the labor and industrial courts, working with unions, taking the issues of workers, and especially those factories who have been locked out and closed down. So I think the court can be used as an excellent forum, as an excellent agency for immediately delivering justice to the court. And I think presently there is no other agency available with us. As lawyers, we have no other alternative because we can't resort to violence and injustice. So the courts are the best forum for us as lawyers, young lawyers, to give justice to the court. I don't think I am a very good speaker. Unless I am encouraged and unless I am educated, unless I am provoked by the other side to speak, I don't speak. So somebody has to provoke me to speak. Somebody has to argue with me to make me argue.
You spoke well, that means we are proud.
So I think instead of just narrating my own experiences about the courts and the cases that I have handled, I would like to share some views about you all who have been able to be here in large number, because these programs act like encouraging moments for us. These are our encouraging doses. We come here and we refresh ourselves. Most of the time, while doing in our profession, we get very bored. We don't think fresh. We don't think innovative. And these are the places which makes us and compels us to do that. So I have come here not to speak about my experiences alone, but also to have a dialogue with you as to what we all can do the best to give justice to the world. I think that's all I can say for the time being. And if you have any questions,
Your participants are invited to ask any questions.
thank you.
So my question is, what is the scope of these new brain mapping tests, narcoanalysis tests as regards this criminal law? Because I think they have no evidentiary value as such. Only they aid in investigation. If suppose we are able to discover some scientific proof of some scientific basis to these tests, then they'll help the prosecution a lot, and the rate of acquittal would go down and the rate of conviction would go high. Because currently, I mean, as far as I have heard in many lectures and all, that the rate of conviction is very low in our country. That's because of prosecution's defect and all. Thank you.
All part of investigation stage. And as you know, if Sharma's case from Delhi scandal, which went in writ petition to the Supreme Court, and he was granted bail by Justice S.N. Sinha, you should read that judgment, which is the authority on the point that those two tests could be used by the prosecution in its investigation. You cannot prevent the prosecution at the threshold from using that test. As Asuri's case, you know, this Delhi, Noida case also, murder case, that those tests were repeatedly used by the prosecution. So you cannot prevent the prosecution from using those. But they have no evidentiary value, they cannot be used in court. Like, for example, dog tracking. Dog tracking also is a little dubious sort of test. Of course, in many of the tests, the dogs fail. That is a different issue. But even if the dog were to trace the criminal, then it is ultimately the human agency which has to be used, which interprets the action of the dog. Again, there is a fault in that. So, these are the two. But I don't think even in the United States, where the investigation is keeping in almost keeping pace with the defense, there is any better test which is available. But they go into the details of investigation, which our investigative agencies fail to do. Like small little things, the hair, the nails, nail clippings from the yes. Our method is only twofold. Number one, third degree method, or number two, confront the witness. Many times the witness, the person doesn't confess. Then you bring, when you suspect that he had done something in association or in the presence of somebody, then that somebody is caught hold of, and he is brought before the accused, and he says, "Tu baap hai bolte ho." And then when he is confronted, this is confrontation method. And so far, I think in our investigative, for our investigative agencies, accused has been the best source of information, and that source is pulled out by third degree methods. And then they justify these third degree methods, which again is a point of human rights, whether really the prisoners have no human rights at all, or they become just non-humans by becoming prisoners. I remember we had in Bombay University, when I was studying, we had Dr. Setna, who was a criminologist. He had written a number of books on criminology. And I was his favorite student, so he used to take me along. So once he said, "Mr. Patil, yesterday I was in the police station and I was watching their activities, and I asked them whether you use third degree methods." So they said, "Naturally we use third degree methods. Look at that, hammering people." So when I asked them, "Is it correct?" They said, "Sir, do you expect us to garland these people? What else do you expect?" Now that is the approach or attitude of the police, and that is the general thinking in the middle class citizens. But then we have also to consider human rights of certain citizens, including the prisoners. So therefore you are right that more scientific methods have to be evolved in order to extract evidence in that test, in order to get conviction of these people. And not only third degree methods, because third degree methods just these dehumanize the whole situation. And it is against the very grain of again what confession for what? To prove the human right of somebody who has been either assaulted or murdered or whatever. And then again, if you use the same dehumanizing methods, then the whole process becomes little dubious. So that is, you are right, that as far as the law stands today, it is only during the investigation, to keep the investigation on the right track, that you could use these methods, but not beyond that. You can't use it in the court of law. But what the police do, the mischief which they commit, we are coming across these, that all that data, if it is in favor of the police, they always put it as a part of the charge sheet. So let the court read it. You know, courts are, again, my thesis, that courts are humans. They read all that. Out of curiosity, out of, they are humans ultimately. They also want to know what is at the bottom of the whole thing. So they read the analysis, the report of the person, the expert, the outcome of that brain mapping, etc., etc. And it does influence the mind of the court. There is no doubt about that. At least a little prejudice is caused to the defense.
I'd just like to add, as far as the Nagpur test argument is concerned, the matter has just been argued before the Supreme Court and the judgment is awaited. But what is argued there is, in narco analysis, you can't even inject the drug without the permission of the accused. So even as an aid to investigation, narco analysis cannot be done if the accused says, I do not consent. I do not consent to the injection of the drug. So how are the police actually injecting a drug into an accused person without his consent? That's a prior issue, and that has been argued, so we'll have to see what they say. Similarly, in lie detector, of course, involves no drug, but against my consent. Can you do it? Now, Bombay High Court has said in the brain mapping case, division bench, Bombay High Court has said with Justice Palshikar, and that matter has come before Supreme Court, that in the brain mapping test, the police are putting the apparatus on you. You don't answer anything. You keep quiet if you want to keep quiet. But we cannot prevent the police from putting that apparatus on you and asking you certain questions and doing certain things. You keep quiet. We are not forcing you to speak, but you keep quiet. And then, of course, the police will keep on recording whatever, recording has to be done. But these are fundamental issues, let me tell you. Brain mapping is not allowed anywhere in the criminal justice system in Europe and America. Lie detectors are not permissible in Europe and America without the consent of the accused person. Right? It is done with consent. Otherwise, if the accused says, I do not consent, it is not permissible, even as an aid to investigation. Here, of course, in India, these matters have come before Supreme Court will be never back. Our sense is that they may not allow narco analysis at all, but they will allow the lie detector test to be done, as Daireshi pointed out, as an aid to investigation. But even that, we are not happy with that.
In our criminal justice system, an accused has a right to be silent. He need not admit his guilt or make any confession. You can't compel him to make any confession. To a certain extent, using narco analysis is making him compelling him to speak against this by putting him in that semi-conscious state of mind. So, in a way, it's a coercive method of making him admit the truth. I don't know to what extent the court is going to take cognizance of these issues, but certainly this would be one of the issues which should call for consideration, is that we can use external aid to compel an accused to speak against us. Whether it can be termed to be any other degree method, maybe not first degree, or second degree, but any other degree more than that, to compel himself to speak against us.
No, by analogy, this narco analysis, any invasive procedure, if the doctor wants to undertake, maybe an injection, maybe anything which is an invasive procedure, and it is an invasive procedure, this narco analysis is an invasive procedure. The informed consent of the patient has to be taken. It is not mere consent, but informed consent as to what would be the prognosis, what would be the effect, whether it is useful or not useful. What are the dangers, what are the risks involved. Now all that is required not only for a surgical procedure, but even in simple diagnostic invasive procedure which the doctor is supposed to undertake. And if he does not do that, then he would be guilty of medical negligence on the part of the doctor, because there are very extreme cases which have been reported even in medical science. For example, I will tell you that if a person is blind in one eye and he has a good eye, the other eye is good, and the doctor assumes that this wrong eye could be corrected, then he must tell the patient that while correcting the bad eye, there is one case in 14,000. Inform to the patient. Similarly, if narcoanalysis entails an invasive procedure, then I think by analogy you can argue that no, this cannot be allowed without the complete, that is, informed consent of the patient, not mere, because it has to be informed, because of, accused should know that it could be used in a court of law against him. It could be used to cull out the confession out of him, and therefore I think that analogy also would be
which is not the violation of human rights.
Absolutely. That we have already said that it is a violation of human rights. You can't say that he is a non-person. Is he a non-person yes, because he is a prisoner? Now that is what Gandhiji had said. Do you know? In the non-cooperation movement, when he arbitrarily withdrew in the 1920s, there were many like Jawaharlal Nehru and others who were in jail. They were opposed to withdrawal. Subhash Chandra Bose, he was opposed to withdrawal of that non-cooperation movement. And when Gandhiji was asked that these people, your other leaders are opposed, he said they are prisoners and prisoners are non-persons. So you did not take, these are words which are recorded.
How many of you feel narco-analysis should be allowed?
Raise your hand.
See, I get a pulse. Yeah. How many of you feel that alleged terrorists should be tortured?
Or killed.
Should be tortured and killed, put up hands.
Don't be scared of airing your views.
We have to understand psychology. When we deal with the rights of a person who is accused of an offense, we can't ignore his psychology. He doesn't commit only a physical act. His mind is also behind it. So what made his mind to ask his body to do that, what he did, is something which relates to his mind. And by torturing, you can't change the mind. By physical torture, you can't change his attitude. I have always thought that at some age, at some age of our life, we are labeled as juvenile delinquents. Ourselves. We are not accused of an offense, maybe because though we were delinquent, we could afford ourselves to escape the process of law. Maybe by our position, maybe our skill or whatever. But mind well, at some point of time, we have done an act which is not, or which is an offense in strict four corners of law. Maybe stealing of a mango, maybe trespassing someone's property, maybe abusing somebody, maybe creating a nuisance for somebody. But we don't think, because we are not caught in that process of law. Though we could afford ourselves to be acting delinquently. But there are some who just act delinquently, but they are labeled as offenders. The torture, if it's created or if it is made on such mind at that age, or maybe at a young age, it's going to create a havoc. You are creating a criminal. You are asking the criminal to be born in his mind. So I think as human beings, we just not allowed to see the physique of that person. There are people who label people as criminals merely on their features. There are schools of thought which identify criminals from their faces, and maybe many of our faces may resemble them. But If we are labeled as criminals on these bases, then I think we are going on the wrong path. Our law doesn't create that trust in the investigating agency. Evidence Act doesn't allow a police officer's statement that is recorded and in investigation to be used as an evidence, substantial evidence. It's only being used to, contradict, not used as a substantial piece of evidence. Why? Because our investigation machinery is still not trusted. And if we put that trust in that investigating machinery and allow people to be tortured by them, I think we are going the wrong way. That's what I think.
काम करतो अशा दोन आदिवासींच्या जात पंचायतीमध्ये मी फसलेलो होतो. तर तिथं गुन्हा कबूल करताना संपूर्ण जात पंचायतीमध्ये काही 5 लोक निर्णय घेतले, जवळपास सगळे लोक बसतात आणि त्याच्यामध्ये त्याला 2-2 दिवस ते लोक बसतात, काही वेळेस 3-4 दिवस असतो आणि त्यांनी स्वतः गुन्हा कबूल करेपर्यंत त्याला कुठली शिक्षा करते आणि त्यांनी जेव्हा स्वतः तो गुन्हा कबूल करतो त्यावेळेस मग त्याचा दंड ठरवतात ते आणि ते झाल्यानंतर तो पुन्हा त्यांच्या सामाजिक प्रक्रियेमध्ये पूर्णपणे सामील होतो. तोपर्यंत त्याला काही त्याच्यातनं ते बाहेर ठेवतात, त्याला समाजाच्या काही कार्यक्रमांमध्ये दूर ठेवतात. पण ही प्रक्रिया की ज्याच्या त्यांनी सांगितलं की त्याच्यात तुम्ही पुष्कळदा अशा पद्धतीने करून त्याला आणखी क्रिमिनल बनवत जातात. तर ही ह्युमन याची प्रक्रिया आदिवासींच्या या जात पंचायतीमध्ये 2-3 केसेसमध्ये बघितली आहे. त्याला वेळ लागतो, त्यांचे 5-5 दिवस, काही वेळेस महिनाभर ती सगळी प्रोसेस चालते. पण त्या व्यक्तीने स्वतः ज्यांनी गुन्हा केलेला आहे त्यांनी कबूल करून करेपर्यंत ही सगळी प्रोसेस. त्याच्यामुळे आपल्या पारंपरिक याच्यातही हा ह्युमन राईट्सचा प्रश्न अशा काही याच्यामध्ये आहे त्या सगळ्या वाईट नाही.
Before we end the session, we have about 5 minutes more. Let us ask somebody, in what circumstances torture would be justified? Come. Let's just speak or forget about the mic. Just stand and speak. Somebody says torture should be justified, police should be allowed to torture. In what circumstances? Come. Go ahead.
So I think it should be in the hardcore criminal cases.
Hardcore criminal cases. Got that. Anybody else? Yeah, go ahead.
Sir, I think first of all we should not start from investigation officer, should not start from confession. He should try to arrive at confession. When he has all valuable evidence, then he should torture the criminal that yes,
correct.
All the evidence.
Correct.
Now you confess. So
correct.
our time is not wasted in court.
So our time is not wasted in court. Very good. Excellent. Next.
Sir, while dealing with the terrorist, because
terrorist, got that. Terrorist should be tortured. Got that. Yes.
Sir, it should be in the cases of hardened criminals.
Hardened criminals.
Yes, sir, and in cases of serial killers.
Serial killers. Okay. What else?
In the case where only the prima facie case has been made out, means there
He should be allowed. Police say correct.